This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about a Qui Tam action, a whistleblower action, where Allstate filed one to take the profit out of fraud. And in this man bites dog story, Allstate has been allowed by the California Court of Appeals to sue on behalf of the state against those they believe are insurance fraud perpetrators. And they will conclude and work on the most effective weapon against insurance fraud, the Qui Tam action, because state prosecutors simply do not take very many cases of insurance fraud in the state of California to trial. Allstate Insurance Company and several of its affiliates brought Qui Tam actions on behalf of the state of California, alleging insurance fraud under the California Insurance Frauds Prevention Act, the IFPA, Insurance Code Sections 1871 et sec, and the Unfair Competition Law, Business and Professions Code Sections 17,000 et sec, against three medical corporations, a medical management company, and its parent company, four physicians, and a person named Sattar Mir, an individual. In the People ex rel Allstate Insurance Company versus Discovery Radiology Physicians et al., the Court of Appeals, 2nd District, 3rd Division, on August 15, 2023, dealt with these Qui Tam actions, noting that the operative complaints allege that while the medical corporations hold themselves out as providers of radiology services, they are, in fact, acting as radiology brokers, sending patients to radiology facilities and radiologists with which the purported medical corporations have contracted. The trial court found the complaints failed to state causes of action under the IFPA and the UCL because they were not pled with requisite specificity. Allstate Insurance Company is an insurance company licensed to issue automobile insurance policies in California. In 2020, Allstate filed two Qui Tam actions alleging insurance fraud in violation of the IFPA and the UCL. The complaints alleged that the three medical corporations were formed and controlled by Mir, who is not a physician, to broker radiology services. The resulting bills falsely identified the technical and professional services as having been provided by one of the three defendant medical corporations and grossly inflated the fees for the services provided. Allstate alleged it would not have paid the claims for services purportedly rendered by these three professional corporations had it known of the false statements and fraudulent markups. The trial court sustained the demurrer to the first amended complaints and entered judgments of dismissal in the two Qui Tam actions on August 16, 2021. Allstate timely appealed. The appeal presented four basic issues. 1. Are the business models alleged in the amended complaint unlawful? 2. If the alleged business models are unlawful, do they give rise to causes of action under the IFPA and the UCL? 3. Do the amended complaints plead fraud with sufficient particularity? And 4. Does the discovery action adequately allege delayed discovery to survive demurrer on a statute of limitations ground? The Court of Appeals answered each question in the affirmative. Analyzing the issues, the court noted that a non-licensed individual need not examine a patient or render a medical diagnosis to engage in the unlicensed practice of medicine. To the contrary, a non-physician unlawfully practices medicine if he or she exercises undue control over a medical practice. A non-physician undoubtedly exercises undue control by owning a medical practice, but may also exercise such control in a variety of ways, including by choosing physicians to provide medical services, selecting medical equipment, determining the parameters of a physician's employment, including caseload and compensation, and making billing decisions. To reach its decision, the court first rendered an overview of the Insurance Fraud Prevention Act. The IFPA was enacted to prevent automobile and workers' compensation insurance fraud to, among other things, significantly reduce the incidence or severity and automobile insurance claims payments, and therefore produce a commensurate reduction in automobile insurance premiums. A claim need not contain an express misstatement of fact to be actionable under Penal Code Section 550 and Insurance Code Section 1871.7, Subdivision B. Instead, these actions require only that a person knowingly and with intent to defraud presents a claim that is false or fraudulent in some respect. 2. Presents, prepares, or makes a statement containing false or misleading information about a material fact. Or 3. Conceals an event that affects a person's right or entitlement to insurance benefits. In other words, quote, an insurance claim is fraudulent under Penal Code Section 550 and Insurance Code Section 1871.7, Subdivision B, when it is characterized in any way by deceit or results from deceit or conduct that is done with an intention to gain unfair or dishonest advantage. In analyzing the issues, the California Court of Appeal noted that the present case is a fraud action brought in the name of and on behalf of the state of California. Nor does Allstate seek to avoid paying for services rendered under an insurance contract, as defendants might suggest. Allstate has already paid for those services and seeks through this action to recover a statutory penalty that, if recovered, will be shared by the state. For all of these reasons, the Court of Appeal concluded that the complaints allege claims appropriately under the IFPA. The UCL prohibits any unlawful, unfair, or fraudulent business act or practice and unfair, deceptive, untrue, or misleading advertising, Section 17,200. All parties agree that Allstate's UCL claims are derivative of its IFPA claims, and thus that the UCL claims rise or fall with the IFPA claims, because the complaints adequately pled violations of the IFPA. The Court of Appeal concluded they also adequately pled violations of the UCL. The court also concluded that the amended complaints were pled with adequate specificity because Allstate has not only pled an allegedly fraudulent practice, but also identified each of the allegedly false claims submitted as a result of that practice. It has adequately pled it with adequate specificity. The judgments of dismissal were therefore reversed with directions to the trial court to vacate the orders sustaining the demurrers, enter new orders overruling the demurrers, and reinstate the amended complaints. It also allowed Allstate to recover its appellate costs from the defendants. In my opinion, the Qui Tam provisions of the IFPA are an effective means of reducing insurance fraud by taking the profit out of the procedure without taking on the need for proof beyond a reasonable doubt in a criminal proceeding. If there is no profit in fraud, and because the IFPA can assess serious damages on the perpetrators, Allstate and all of the amici who supported it on its appeal should be honored in the work to defeat fraud and should be emulated by other insurers who are the victims of fraud providers, whether medical, auto, body shops, contractors, roofers, public insurance adjusters, and lawyers. It will reduce fraud and fulfill the reason for the enactment of the IFPA. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog, and you will gain access to each and every blog posting, usually 5, sometimes 6 a week, and to the more than 4,550 blog postings available on the internet by simply entering a query into a search bar on the blog. You can also subscribe to the videos on YouTube and rumble.com, also for no cost. And if you enjoy or learn from these blog postings, please click on the like button or the thumbs up button on Rumble. And if you really want more detailed information and about insurance, insurance law, insurance claims, and insurance fraud, for a very small fee, please consider subscribing to my Locals community and my Substack publications. Thank you for your attention.